Bishop Fann here, wanting to share with you today about the 14th Amendment. I need for you to listen to this 14th Amendment, take notes, understand what the 14th Amendment did, understand how it affected people of color and the voting rights of people of color. So listen to it attentively, take notes, give it to your kid, let them take notes, let them learn more about the 14th Amendment. There are three branches of government that we need to understand. It is the legislative branch, it's the executive branch, and the judicial branch. The judicial branch serves as the Supreme Court. The Supreme Court serves as the judicial branch, which many times they make decisions as to what's constitutional, what the Constitution mean, or what the Constitution didn't mean as it relates to certain constitutional rules and regulations that's in the Constitution. Then you have the executive branch, which is the President of the United States and his cabinet. Those are the executive branch of the United States. And then you have what we call the legislative branch, which is the ones who make the laws. Those are the senators, the U.S. senators, and the U.S. Congress people. So learn the branches of government, learn the duties of each branch of government, and listen to the 14th Amendment and learn more about your country and what governs you as a citizen in this country. We'll be back on the other side.
Today we're going to talk about the 14th Amendment. Let's begin with the text. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. That's the Citizenship Clause. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. That's the Privileges or Immunities Clause. Nor shall any state deprive any person of life, liberty, or property without due process of law. That's the Due Process Clause. Nor deny to any person within its jurisdiction the equal protection of the laws. That's the Equal Protection Laws. Well, where did this language come from? Let's tell the story of the 14th Amendment. And it's such an important and interesting story. It follows from the backlash against the 13th Amendment to the Constitution, which banned slavery in the U.S. And after the 13th Amendment passed, Southern states tried to reintroduce slavery by other means, by passing a series of laws called the Black Codes. And these codes denied the newly freed African Americans the right to sue and be sued, to make contracts, to inherit property, and basically to exercise the basic civil rights of citizenship to which they were entitled. Congress responds by passing the Civil Rights Act of 1866, which says that all people in the United States are entitled to the same civil rights, to make and enforce contracts, to sue and be sued, all the rights that the Black Codes had denied. The thing was that Congress wasn't sure it had the constitutional authority to pass the Civil Rights Act of 1866. And therefore, Reconstruction Republicans, led by John Bingham, thought that the 14th Amendment was necessary to make clear that Congress had the power to enforce the provisions of the amendment by appropriate legislation, and also to guarantee the equal civil rights or privileges or immunities of citizenship. So at the core, the 14th Amendment is designed to constitutionalize the rights in the Civil Rights Act of 1866. Then the first sentence of the amendment overturned the part of the Dred Scott case that said that Black people couldn't be citizens and had no rights that white people were bound to respect. But then the question is, who's entitled to birthright citizenship? And the first test case was called Wong Kim Ark, and it was decided in 1898. Wong Kim Ark was born in San Francisco to parents who were both Chinese citizens who resided in the U.S. at the time he was born. And at the age of 21, he returned to China to visit his parents, who'd previously lived in the U.S. for 20 years. And when he came back to the U.S., Wong Kim Ark is denied entry on the grounds that he's not a citizen. Under the Chinese Exclusion Act, which was in force at the time, no Chinese subject could become a citizen. He objected. He said he was born in the US and therefore was entitled to citizenship, and the court agreed. Because Wang was born in the United States and his parents were not employed in any diplomatic or official capacity under the Emperor of China, the citizenship clause of the 14th Amendment automatically made him a US citizen. Justice Horace Gray wrote the opinion on behalf of a 6-2 majority. And the court concluded that under the 14th Amendment, it didn't matter who your parents were. It mattered where you were born. And if you were born on American soil, you were automatically a US citizen. The exceptions were Native Americans and diplomats who were not subject to the jurisdiction of the United States. The second big idea in the 14th Amendment is the Privileges or Immunities Clause. And the first test case was called the Slaughterhouse Cases. Really interesting and important case. And the basic question was whether a company called the Crescent City Company in Louisiana had created a monopoly when the city of New Orleans set up a grand slaughterhouse, basically as a health response to the fact that there was all this disgusting offal that was being poured into the river at a time when all these slaughterhouses were killing meat to be transported across the country in newly refrigerated railroad cars. So the basic legal question is, does it violate the 14th Amendment to create a monopoly? And also, was it a monopoly to require anyone who was a butcher in New Orleans to use this slaughterhouse? The court could have just decided that question either way and not really disrupted the law. But instead, the majority went out of its way to narrow the Privileges or Immunities Clause of the 14th Amendment in a way that basically read it out of the Constitution. The majority said that the privileges or immunities of US citizenship are a very narrow category of rights that were already protected in the existing Constitution before the 14th Amendment, like the right to have the right of habeas corpus, for example. Now, the dissenter said this is completely contrary to the original understanding of the 14th Amendment, whose authors stood up in Congress, said that the purpose of this law is to incorporate or apply all of the original protections of the Bill of Rights so that they bind the states as well as the federal government, as well as to ensure that all citizens have the same privileges or immunities, including the right to sue and be sued, to inherit property, all those rights that were in the Civil Rights Act, which was the whole point of the 14th Amendment in its original passage. And the dissenters objected that the privileges or immunities of US citizens were far broader than the majority had said. It would take almost a century for the Supreme Court to agree and slowly to incorporate or apply individual provisions of the Bill of Rights against the states, but the court had to do it through the Due Process Clause, not the Privileges or Immunities Clause, because the Supreme Court in Slaughterhouse had read the Privileges or Immunities Clause out of existence. This is one case that there's a lot of consensus by liberal and conservative scholars that it was wrongly decided. It was inconsistent with original understanding, but the Supreme Court has not proved ready to re-examine it. The third big thing that the 14th Amendment does is guarantee the equal protection of the laws. Soon after the 13th, 14th, and 15th Amendments were passed, their promise was undermined by Southern redemption and by a series of laws passed mostly in the South that restricted the rights of African Americans. This system of segregation was known as Jim Crow segregation, and it forced African Americans to attend different schools than white people, to drink from different water fountains, to use different restrooms, travel in different railroad cars, and stay in different hotels. The states also used a mix of violence, intimidation, and laws, including poll taxes and literacy tests to keep African Americans from voting. And then finally, less than 2 decades after the 14th Amendment passed, the Supreme Court issued its infamous decision in Plessy versus Ferguson in 1896. Well, what happened in this case? Homer Plessy was working with a group called the Committee of Citizens, which opposed Louisiana's 1890 Separate Car Act. That act segregated railroad cars within the state. It separated African Americans from white passengers and said that African Americans had to ride on separate railroad cars. There was an exception for nurses. If you were an African American nurse, you were allowed to ride with the white folk, but not if you were not a nurse or in a position of equality. That by itself might have given away the real purpose of the law. Plessy was chosen as a test case so the group could challenge the constitutionality of this law, Plessy appeared to be white and was born free, but he was of mixed race, and therefore he was considered black under Louisiana law. And Plessy and his allies hoped that his arrest would prove the arbitrary nature of the law. But in a 7-1 decision, Plessy lost. Justice Henry Billings Brown wrote the majority opinion upholding separate but equal laws. According to the Supreme Court, Jim Crow laws were constitutional. The court concluded that these laws didn't violate either the 13th Amendment, which abolished slavery, or the 14th Amendment, which promised equality. Here's Justice Brown. While the object of the 14th Amendment was undoubtedly to enforce the absolute equality of the two races before the law, in the nature of things, it could not have been intended to abolish distinctions based upon color, or to enforce social as distinguished from political equality, or a commingling of the two races upon terms unsatisfactory to either. Justice Brown for the court argued that the law was a reasonable use of the state's police power to regulate the health, safety, and morals of its population. And Justice Brown said the underlying mistake of Homer Plessy's argument was the assumption that the enforced separation of the two races stamps African Americans with a badge of inferiority. If this be so, he said, it is not by reason of anything found in the act, but solely because African Americans choose to put that construction on it. But Justice Brown's arguments did not go unanswered. Justice John Marshall Harlan was the sole dissenter. His dissent is one of the most important and powerful dissents in Supreme Court history. Here are Harlan's words. In view of the Constitution, in the eye of the law, there is in this country no superior, dominant, ruling class of citizens. There is no caste here. Our Constitution is colorblind and neither knows nor tolerates classes among citizens. In respect of civil rights, all citizens are equal before the law. And then Harlan went on to say that, in my opinion, the judgment this day rendered will in time prove to be quite as pernicious as the decision made by this tribunal in the Dred Scott case. Well, his prediction came true, and Harlan said that everyone knew the real purpose of the Louisiana law. What can more certainly arouse race hate, Harlan said? What more certainly create and perpetuate a feeling of distrust between these races than state enactments which in fact proceed on the grounds that colored citizens are so inferior and degraded that they cannot be allowed to sit in public coaches occupied by white citizens? That, as all will admit, is the real meaning of such legislation as was enforced in Louisiana. In other words, everyone knew what the real purpose was. It wasn't a neutral purpose to exclude white people from railroad cars occupied by African Americans, or a neutral purpose to accommodate the desires of both black and white people, but instead a racist desire to exclude black people from coaches occupied by white people based on a premise of black inferiority. Everyone knows, said Harlan. And eventually, the U.S. Supreme Court came to agree. To see how the court eventually came to agree and gave meaning to the promise of the 14th Amendment, let's fast forward to 1954 and to arguably the most famous and important Supreme Court decision of the 20th century, Brown versus Board of Education, decided in 1954. Thurgood Marshall, who was the head of the NAACP Legal Defense Fund, and the great hero who argued Brown versus Board of Education, read Harlan's dissent for inspiration before he argued the case. And Brown was the culmination of a long-term, decade-long strategy by the NAACP and its lawyers like Thurgood Marshall and other great heroes to challenge Jim Crow laws. In Brown, they targeted the segregation of public schools, but the genius of their strategy was that it was a gradual campaign to undermine segregation in other contexts first, like public universities and law schools, before turning to segregation in public elementary and high schools. That was a much more controversial issue because it affected lots more people, and Marshall realized it was best to start with law schools before working his way up to public schools. For example, in Sweat v. Painter in 1950, 4 years before Brown, the court already questioned the separate but equal doctrine of Plessy. That was a case involving Herman Sweat, who was refused admission to the University of Texas Law School on the basis of race. And the court said that was unconstitutional under the Equal Protection Clause because the supposedly separate but equal law school that Texas had set up was patently unequal. The Brown case combined challenges from a bunch of locations: Kansas, South Carolina, Virginia, Delaware, and also Washington, D.C. These cases all involved African-American students who'd been denied admission to white public schools. The challengers all argued that segregation violated the 14th Amendment's Equal Protection Clause and that separate could never be equal when it comes to public education. And in Brown, the Supreme Court unanimously agreed. It overturned Plessy and concluded that school segregation violates the 14th Amendment's promise of equality and was unconstitutional. Chief Justice Warren held, "We conclude that in the field of public education, the doctrine of separate but equal has no place. Separate educational facilities are inherently unequal." The court concluded that even separate but equal facilities are in fact unequal because separating the races results in a brand of inferiority imposed on African American students. In the end, Brown attacked the core of the White South's Jim Crow laws and reinvigorated the 14th Amendment's promise of equality. After Brown, the Supreme Court extended the reach of the Equal Protection Clause to cover discrimination in other settings. And in 1963, on the Washington Mall, Dr. Martin Luther King said that the Declaration of Independence was a promissory note, a promise that all men, yes, black men as well as white men, would be guaranteed the unalienable rights of life, liberty, and the pursuit of happiness. The following year, Congress passed the Civil Rights Act of 1964, a sweeping civil rights law promoting equality. Along with Brown, the Civil Rights Act helped to make the promise of the Declaration and of the 14th Amendment a reality.
I certainly hope that you receive something from this constitutional exercise about the 14th Amendment, that you gain knowledge and an understanding what the Constitution allows for and what the Constitution does not allow for. I ask that you share this with your family and friends to understand how we're dealing with the things that we're dealing with when we have a former president of the United States that's running again, who has said that he wanted to do or want to do away with the Constitution, which we have lived by for our lifetime and long before our lifetime. But we want our young people to understand that this is what governs the laws of the land, is the Constitution of the United States. The state has a constitution, and it's the state constitution. But all constitutions, whether they're states, cities, or counties, are governed by the U.S. Constitution. It cannot come in conflict with the U.S. Constitution. So this former president wants to do away with it entirely so he can become a dictator and dictate as to how government will run and how we will be governed as citizens of the United States. Don't be fooled, don't be tricked. Share this information with your family members and your friends. Know the Constitution, know the branches of government, and know how they affect